licensing of floodplain harvesting in order for government to be able to better regulate this legitimate form of water access. And this amendment, this exemption regulation, is a critical component of moving towards that licensing framework, which will come into effect mid-next year. So the exemption ultimately allows for the better management of floodplain harvesting as part of that process, which provides all that's still managed under the one framework rather than having part of it still managed under the 1912 Act. We would like to say, though, that this is an interim measure and it should only be in effect until the proper licensing framework comes into effect, because that's when floodplain harvesting can be best managed by government.
Okay, thank you. And Claire, do you have any, or you're leaving it with Christine?
I will leave that with Christine. This is my second day, so I'm on a steep learning curve. Okay,
thank you. Well, I might weigh in with the first question if the committee members are okay with that. I hope you've had a chance to look at the submissions that have been made public. One of the submissions is pretty damning of the regulation, and in fact asserts that it is illegal, that the arrangement that's been put in place is illegal. I'd be keen to get your views on that.
This is actually making it more legal. So at present, floodplain harvesting is established as a right under the Water Act of 1912. What this is doing is bringing it into the contemporary legislative framework. So under the Water Management Act of 2000, all water take has to be either under an appropriate water access licence, under a basic landholder right, or under a licence exemption. So in the process of moving to that more permanent licensing framework, this provides the exemption to shift from that 1912 right to an exemption under the Water Management Act. So what it's about is consistency and streamlining. So it's under one piece of legislation, which gives both the government and water users, and I'm talking about water users on floodplains and downstream, certainty over how this is actually managed. So this is actually a vital step of improving the way that it's managed and provides greater clarity around what those legal access arrangements are.
Okay. And the other thing that's been raised, a very common theme in just about all of the submissions, was the very poor communication or even lack of communication around the implementation of the regulation. I'll be keen to get your views about that, but more so, if you think it was poor or it lacked communication, what would you suggest is a better way of having done this so we don't make the same mistakes again?
Well, ultimately, this exemption regulation was foreshadowed years ago in the floodplain harvesting policy, but it came into effect at a very critical time, around the time of a first flush ban. And for many people, it got confused with the embargoes which were put in place, which is the subject of a separate inquiry. And part of that was because this exemption regulation lacked explanation by government about what the purpose and intent was. And perhaps if there was better explanation around what the intent of this regulation was, so that the community could better understand the purpose of it, then that would have assisted with people understanding that this is a necessary step for government to better manage this form of take. Ultimately, it was put in place the day before the floodplain harvesting embargo, which was the first ever floodplain harvesting embargo, came into effect, and that caused a lot of confusion for people. So for us, communication on what is very complex and technical matters from government is incredibly important, so people can have confidence in the system of water management. So we do think that that could have been done a lot better.
And so you talk about the technical aspects of this. So if there was a decent lead-in time for the introduction of the regulation rather than the very quick approach as you indicated, how long would that lead-in time be and why?
Well, this was foreshadowed years ago. Yeah, it was foreshadowed years ago as part of this, and this is part of the transition from the 1912 Act in order to bring it into the 2000 Water Management Act. So the sooner that this can be brought into the contemporary legislation, the better. And what this now provides, if this exemption regulation continues, is for it all to be part of the same legislative framework. So the sooner that can happen, the earlier that people can have clarity and confidence to know that this is managed in a consistent way.
Yep.
My understanding is that, yes, this has been actually foreshadowed for several years, and obviously had it been brought in several years ago, we wouldn't have had the confusion and the conflation of two quite separate issues in February. So I guess what we learned from that is that if it's foreshadowed, governments need to act and bring these things in rather than, you know, have sort of delays that then lead to the kind of confusion that we're in at the moment.
Okay, thank you. Now, the committee members, I'm going to make sure we all get a fair go at this, otherwise I'll hog all the questioning, so which is not fair to everyone else. Kate Fairman has indicated she has a question or two, so Kate, I'll go to you.
Thanks, Mick. Hi, everyone. I've just got a question based on your submission on page 8, where you talk about the outstanding issues in relation to floodplain harvesting. And on page 3, you suggest that, page 8 at point 3 there, you suggest that additionally there remains uncertainty for those water users where there is a dispute with the government regarding the eligibility of flood protection works to be used for floodplain harvesting, despite the historical practices. You say that these water users must be provided the opportunity to resolve these issues. Could you explain what those issues are and what that refers to?
My understanding is flood works approvals were through a Part 8 mechanism back years ago. Back in the 80s, people applied for flood work, levee banks and what have you, through trying to be nice to the government, but after 35 years or 30 years, there are some people who still haven't had those applications processed. So there's some levee banks, farm infrastructure has been in place for 30 years and still not licensed through that program, which they're working through now. But it's
so it's illegal in other words?
No. There's been applications in place for 30 years since the late 80s, but through the government process, they have never been finalised. So, in my understanding, the departments are well aware of all that infrastructure, but technically they have not finalised the licensing of it, but it's in the process.
So it's our view that we feel that government needs to get on with better managing floodplain harvesting, and this is a critical component of doing that. And there is a view by water users that we feel a bit left down by the process which has been occurring, and we need measures like this to come into effect so that it can be better measured and so that it's clear and that people understand what their access arrangements are.
I think if you have an application that's been sitting there for 30 years to be processed and approved, you've got irrigators actually trying to do the right thing. And if it's taken 30 years, the government to process their applications, that's hardly the fault of people actually trying to do the right thing and wanted to be within, make sure that everything is in fact legal.
It's rather telling of the whole process.
Yep.
I've got more, Mick, but I'm just conscious of others. I'll come back to me. Yeah.
Okay, thanks, Kate. So Justin Field has indicated he's got a couple of questions. So we'll go to Justin.
Thanks, Mick, and thanks for your attendance here today. I have a question that comes straight out of your submission. You note on page 4, it's important to note that if the regulation did not exist, water users would still have legitimate access to floodplain harvesting, including rainfall runoff due to existing rights within the Water Act 1912. Does that mean that now this regulation is in place, you feel that has superseded those rights under 1912?
I guess this whole process is a process of transitioning from one act to another. The end game is having the licensing framework in place, and this is just one step to get there. It would be something you'd have to get legal advice on, but my understanding is that until the permanent licensing framework is in place, then those 1912 rights stand until such a time as that is repealed. And when the licensing framework comes into place, then those elements from the old Act will be brought forward and then be contained within the new Act.
So doesn't that effectively mean that the status quo remains regardless of this regulation until the Healthy Floodplain project and the licensing arrangement is fully implemented?
Yeah, pretty much. It's not going to create any more, any less take of water because it's an administrative transitional step. So for us, it provides certainty and clarity because it's easier for things to all be in the one Act rather than having bits and pieces everywhere. But you're right, it doesn't actually change the volume that can be taken at this stage of this regulation.
So I know it's semantics to a degree, but doesn't that indicate that this regulation is not actually needed? It's not actually a transitional arrangement. It doesn't change the situation on the ground for you at all. It doesn't assist with the management. 324 orders were still available and able to be made anyway. So it's not related to that. So this regulation is not really needed.
The issue is that floodplain harvesting is a very complex and controversial issue, and the more simple that we can make the regulation and the better that we can communicate to the public, then it'll allow people to have greater confidence in the way that it's managed because it will be more clear and more simple. Now, the Water Management Act, as I was saying earlier, it requires a license, an exemption or a right. So to actually have this brought forward into our contemporary legislative framework, it makes it easier for people to understand because it's clear, it's all in the one place. So our interest is to have that licensing framework in place. That's the ultimate end goal. This is a step to get there, but we don't want this to exclude or preclude or delay getting to that licensing framework stage. But it's an important part for the community to have confidence that this is managed appropriately and sustainably.
So it would be the position of the Irrigators Council that this regulation should no longer exist once the Healthy Floodplains project is finalised and the licensing arrangements are in place. So it'd be appropriate for this regulation to sunset at that point?
For those valleys. So the Healthy Floodplains project is only for those 5 northern valleys. What we need to remember is that the definition of overland flow in the Water Management Act includes rainfall runoff. Now, all irrigation farms are required to capture rainfall runoff. That's for environmental reasons, so that there's no contaminants leaving the farm and going into river systems. So this is a matter for other valleys across the state as well, who are required to capture the rainfall runoff from their properties. So for those northern valleys where a licensing framework is coming in next year, then yes, a sunset clause would be what we're after. But we just need to remember that this is a statewide matter, and until such time as there's a licensing framework for other valleys, if that is the intent, then we need to be mindful of what impacts this is going to have on other valleys as well.
So Mick, I'm conscious of others as well. I do want to get into this issue of rainfall runoff and passive take, but I'm happy to pass on to someone else and come back to that if you like.
Thanks, Justin. That's right. We've got a couple lined up now. So next will be Rob Borzak and then Greg Donnelly. So Robert?
Yeah, thanks, Mick. Good morning. Can you explain exactly to me, rather than just using the words interim measure, what you believe this regulation is actually doing for you? Because I, like Mr. Field, fail to understand its relevance.
Well, it was my understanding it was a procedural matter that was required to allow the Healthy Floodplains project to proceed. So I'm just an old farmer from Moree. So that's how it was explained to me. And I thought, well, if that's how it has to be, that's what has to be to allow this project to move on, to create certainty. So for everyone.
Yeah,
so with due respect, you don't actually know what it does. No,
so there's 2 options essentially for government. One option is that the status quo continues, where floodplain harvesting remains within the 1912 Act until such time as it's brought into the licensing framework, or we have it all within the contemporary Water Management Act under an exemption until the licensing framework comes into place. So the difference between the status quo and this is whether it's under the old Act or the new Act. From my perspective, it should be government's intent to have things consistent with the contemporary legislative framework. That is good practice, that is the best practice of water management, because the Water Management Act allows government to have greater management and control over floodplain harvesting take than the 1912 Act has. So this actually puts government in a position to better manage floodplain harvesting than under the 1912 Act, because there's more mechanisms and instruments in our contemporary legislation than there was at that time. So this is in the interest of government to be putting this in place so they can manage it within their act.
Well, yes, and I understand that, but what's your understandings of the mechanics? Because you haven't quite answered my question of the mechanics, how this regulation will function in that way. I mean, why has it taken, in your view, this government 9 years to finally address this?
I don't think we can answer for the government. That would be a question for the minister.
Well, no, that again, with respect, that's just trying to whizzle out of the question. I asked your view. I didn't ask the government's view. I'll ask the government's view this afternoon when the minister comes on. Are you saying you don't have a view?
It's a complex and technical matter. It's not a simple.
Yeah, sorry, I've heard you say that about 10 times. What are the complex matters that this regulation is trying to deal with?
The Healthy Floodplains Project implementation.
And what's your understanding of that? What does it do? How does it affect you as a farmer?
The Healthy Floodplains project has two components to it. One component is about better managing the environmental health of floodplains.
What we might do, Greg, is I might get the Secretariat to ring your mobile and see if we can get you on that way. It's just not unmuting for some reason. Yeah, sorry about that, Greg. It's technology. Yeah. Okay. Whilst we're trying to help Greg with his technology and probably at our end as well, can I just ask, your submission talks about the better regulation principles of government, and you're actually, I suppose, my words, not yours, but you're critical here that you say that the department did not follow the government's own guidelines for developing good regulations, which if they did would have avoided much of the confusion and misinformation surrounding the implementation of the regulation. I know there's a few regulations in the water space. How often is it your experience that the government doesn't adhere to its own better regulation principles?
I think
We've lost you as well now. Hang on. Sorry, we've seemed to have lost you as well. Can we just see what's going on there? Okay, you should be right now.
Yeah.
Yes.
I think that if we have regulation principles, obviously it really assists if government follows them. And if this exercise delivers anything, a reminder and a recommitment to actually sort of doing, abiding by these regulation principles would be good. I'm sure this is not the one, but there's been confusion because things have been rushed perhaps at the last moment and not done in a timely manner. And we would be very supportive of any move to basically remind government agencies that these sort of regulation principles are there for a reason, and to have a greater commitment to them.
Okay, thank you. Now, we've got Greg Donnelly on the mobile phone. We're pulling out all stops here to get Greg into this. So, Greg, hopefully you can hear me.
Yes, I can, Chair. Thank you very much.
Okay, and can the witnesses hear Mr. Donnelly?
Yes.
Yep. Okay, Greg, away you go.
Thank you, and good morning from Western Australia. So that might be part of the reason why it's a bit difficult to get through. Listen, thanks for the witnesses for coming along, and thank you very much for your helpful submission. My question is this, that do we not face this situation that this regulation's been put into place, and in the doing of that, there's been much confusion planted in the minds of the growers and the users. In that, yes, they were aware that there was going to be some regulation in due course, but it happened very quickly with the little consultation that's been described in your submission, and created, as you in fact described, a lot of confusion. So that was done, that has happened. But I presume that still not fully understood by all of the members of the organisation, the full implications of what's being done. And they face this situation that, to the government's best timeline, in June next year at the latest, there will be legislation. So they'll be put through again a whole exercise of trying to come to terms with and understand a new legislative framework. That, having said that, would it not make more sense to say to the members, listen, let's just do this properly through the Act itself. That's what we're working towards, and that we continue what is the status quo, which has been operating for a very long time, and in one full exercise come under the new framework of an Act. and let's just put this regulation aside because it created so much confusion and uncertainty. So that's my question. Would it not make a lot more sense to just allow the members to look forward to the new legislative framework and work with them to achieve that and with government, but not have all the uncertainty and wonderment about what's going on with this regulation until the Act fully comes into place?
Yeah, it's a good question. I think it comes down to if we're talking about the exemption regulation itself or the way in which it was implemented. If we're talking about the exemption regulation itself, it does provide that clarity and consistency so that people do have that understanding of how it all works. If we're talking about the way it was implemented, then it was implemented very poorly and the timing was very poor. The intentions weren't communicated well, and that led to the misunderstanding. So it's our view that this regulation does allow for greater understanding and for greater simplicity and a better way for it to be managed. However, because it was implemented poorly, then that intention wasn't realised in the first instance. But I'd say there's still opportunity for government to actually, and particularly through this inquiry, to come out and explain the actual intent of this regulation, what it will achieve and what it will not achieve, and what the next steps are for government in regulating floodplain harvesting. If that was to occur, then I feel we would be able to win on both points, because the regulation, and we as in people who want this managed well, we would be able to achieve the regulatory settings that are clear and consistent, and would also be able to have people understanding that by having that communication with the community.
So the follow-up question is, so are your members saying that that's what they want, that they in fact want to operate under this regulation and then go through a whole nother exercise of the implementation of an act? In other words, to do it in these two stages. Is that what they're saying to you?
Well, people want the Healthy Floodplains project in place. That's what they want, and that's been going on for years to try to get to that. That's our end point, and if this is a necessary step to get there, then that's part of it. But what our members want is for that licensing framework to be in place so that those on the floodplains have the certainty and those downstream have confidence that it's managed properly and sustainably as well.
But sorry to interrupt, but I mean, who is saying to the members, or in fact other members saying back to you, the leadership of the organisation, that this is a necessary step? I mean, the phrase necessary step, where does that come from?
The department. We've been informed by the department that this was a necessary step in the implementation of the Healthy Floodplains project.
It actually comes from the policy itself. If you read the New South Wales Healthy Floodplains policy, and if you have a look on page 4 of our submission, there's an extract from it. And it actually says that an exemption is required so that XYZ, you can read it on there. And it explains that this is needed as part of the process. So it's not so much that we see it as an interim step, it's that we have been informed by reading the policy and by the department that this is what's required.
Sorry, Mick, I have a follow-up question on that specifically, if that's all right.
Yeah. Is that all right, Greg?
Yes, thank you, Chair.
Okay, Justin, your follow-up.
When you say this was a step that was necessary, and you also said before the problem was with the way it was implemented, what you're talking about here is the embargo and then the exemption orders, right? The government has said that this regulation was necessary in order to put in place the embargo and then the exemptions. Is that the implementation stuff that you're talking about? You're not talking about the regulation itself, but what followed after that regulation came in, which was the embargoes.
I think it's really important to separate the embargo and the exemption. It's unfortunate that they came in at a similar time, but they are entirely separate and they should be treated separately by government.
But the implementation, I mean, we've already established that you didn't really need the regulation. You got the 1912 rights. I agree. The government has said it's needed, but the implementation that you're talking about was the embargo process, not the actual regulation being gazetted, because that didn't change anything on the ground for you at the time.
No, but the commentary that followed from this exemption regulation coming into place, That's what we're talking about. It is an entirely separate matter to the embargo, and it's important that, given that there's a separate inquiry for that, that it's treated separately. But what we're talking about here is the way this exemption regulation was implemented, in the sense around how that was communicated to people, what explanatory material was provided to stakeholders, what communications came from government to assist in understanding what the intent of this was. And that's why we were referring to the good regulation principles of government, because we feel that had things such as, you know, proper consultation have occurred, and, you know, winners and losers being identified, and why this is in the public interest, had components like that being properly explained to people, then in the implementation of the exemption regulation, people would have understood why it was an important regulation to come in.
But if it just maintains the status quo until the final policy, how does it matter?
Well, in effect, yeah, that's what it's doing, but it provides clarity and consistency. And we feel that it's important that the public can have confidence in the way this is managed. And if this means people can have confidence because it's all in a one clear, concise act, then that's a better outcome for government. And the mechanisms of the Management Act actually give the government more powers and more ability to be able to manage this. So it's in the government's interests in many ways.
I guess we're
Can I just-
beholden here to the government. We were advised that this was a procedural step that was necessary by the government. It wasn't something that we were pushing for or anything. We accept that there are procedural matters when doing water reforms, and we're supportive of the ultimate objective of this water reform. So,
okay. Can I just check? So, Greg, have you finished with your questions? He's gone. Well, then we'll move to Kate.
Thanks, Chair. I just wanted to ask you a couple of questions in relation to the legality of the floodplain works, basically. So, has the Irrigators Council received? Do you have legal advice as to this? You keep going back to the 1912 Act and what's been approved or what's taken place under Part 8. So I take it you've got legal advice that those works are all legal under 1912?
Well, it's been accepted into the Healthy Floodplains project. Farms with works, with as long as they have applications in the system, they're part of the process. So I take that as the government accepting that situation.
So have you received, has the Irrigators Council received, I mean, you would think, as you're such a huge, powerful body with powerful interests, that you also have legal advice. You've sought legal advice to that effect?
Not that I'm aware of.
We haven't sought legal advice ourselves, no.
So I have one submission that has been provided to this inquiry that does say that in relation to the regulation, that the exemption, which is the clause 39AA, eligible works, it says that this exemption appears to ignore works constructed on or before 3rd of July 2008 that do not have approval. As you know, I'm sure you're aware of that bit. And then they suggest that their concern is that the regulation as currently worded gives an exemption to floodplain works that do not have approval. This is a form of retrospective approval for works that have not been assessed under any formal process. So why, I'm just interested in your view as to why we would have submissions that are saying this to this inquiry.
I'm not sure, but what I do know from on the ground, the department through this Healthy Floodplains project and NRAR and everything else are going through and assessing all the works for this project, and if they fail, they are out of the project. But
what do you mean if they fail?
Well, they're not going to get a license, but that would be better. That would be a question to put to the department later on today, which I understand coming before you. That would be a good question for them.
But you are suggesting that all of the works are legal now, though, yes?
Well, if it's the works to be part of the project, that if they weren't legal, they would be rejected by the project. If the project is allowing those works to come into place, they will be legal. But it will be a question to put through to the department this afternoon.
You're right, Kate?
Thanks, Mick.
Okay. Can I just follow up very quickly though? You mentioned NRA, the Natural Resources Access Regulator. Can you, so what's the impact or what's the implications for NRA of this, as you would understand it, of this regulation coming into effect?
I've really got no idea, Chair.
Okay.
Mine
Yep.
would be that it just provides the clarity for NRA rather than having to look at various different axes all in the one place. It's clear.
To provide clarity.
That's my
Yep.
understanding.
Okay. Yep. So next on the list here, I've got Mr. Justin Field. Justin?
Yeah, thanks, Mick. My next question had to do with your mention of rainfall runoff and also the discussion around passive take and how that's related to the regulation, the policy, and some of the other orders that have been given around this. In your submission, you talk about the 1912 Water Act rights to legitimate access to floodplain harvesting, including rainfall runoff. Can you just explain what you mean by rainfall runoff?
So when we talk about rainfall runoff, that's the rainfall that falls onto the property, moves across the property. So in New South Wales, all farms are required to capture that rainfall runoff because as it moves across the farm, it could pick up contaminants or pollutants from the property, and that we don't want that entering into the waterways. So farmers are required to capture that rainfall runoff. Now, under the Water Management Act and its section 4A, overland flow water, which is the term for the water that is harvested using floodplain harvesting, that includes rainfall runoff. So that's why this is significant for all farms in New South Wales because it's a statewide policy. And if we're talking about overland flow water, then we're also talking about that rainfall runoff component, which all farmers are required to capture for environmental purposes, and that's a legislative requirement. So
the rainfall runoff wouldn't just mean any property. I mean, it'd be talking about if it's flowed rainfall, it's runoff land that is being cropped, for example, where there might be fertilizers and the like. You know, if there was a grazing property, for example, and there was overland flow that went over that and rain had fallen off that and was running off it, they're not required to capture that water, correct?
No, I don't believe so in a strictly dryland situation, but if it was a developed situation like a feedlot, for instance, would you prefer to have the rain?
No, I'm not making the argument. I'm just trying to get the definition.
Into the river, I'd say not. So I think that's why agriculturally contaminated water is turned into this rainfall runoff component.
No, I'm trying to understand the definition.
Justin?
Yep.
Sorry, Justin. Where Justin's going here is around definitions and trying to get our heads around the various definitions. That's what I'm trying to understand so what does it actually mean when the department tells us this is what passive take or whatever. So I hope that helps, Justin.
Chair, maybe it'd be better to ask the department later on for their interpretation of their terminology.
I definitely will, and I appreciate that comment because I've tried with them before. I'm going to try again this afternoon. But you mentioned rainfall runoff. Obviously, not all of a large cropping property would be undercrop. Parts of it wouldn't be. So I'm just trying to understand. Sorry, that's just got a lot of feedback coming on the line there. I'm just trying to understand if you feel like all water running across your property needs to be captured, or if only water that's run across a cropped bit of land or any water that's fallen on that land and run off. Obviously, a lot of the properties up there are actually designed to be able to sort of move water around the property, potentially run it over a cropping field. I'm just trying to understand what that means in practice.
Yes, sir, that's correct. And a developed irrigation farm generally has a levee bank to keep floodwaters out, and it also has drainage inside for the effective efficiency of irrigation and to control rainfall runoff and from rain events and actual tailwater. So it's all part of the equation. The whole farm has been developed around water, as opposed to a dryland farm that hasn't been. It's undeveloped.
Yeah. Okay. So my next question is, in the orders and the embargo and then the orders lifting them temporarily, the government exempted passive take from being embargoed. What is your understanding of what the department means by passive take?
My understanding of passive take is water that cannot be held out of a channel or a system because of the way it's designed. It could be an open-sided dam on the side of a hill that just runs down like a conventional stock dam. That is, as a result of its design, is passive take. You cannot stop.
So for an irrigated property where there is a channel or a berm or an embankment to prevent water running onto a crop, those properties would largely not be affected by passive take because that water is being prevented from accessing that part of the property, correct?
It depends entirely on the topography of the farm.
Okay. Is it your position that passive water taken passively on a property, it might move into a channel or move into a storage area passively just by gravity across the property? Is it your position that is floodplain harvesting?
Passive floodplain harvesting. One thing I do know, sir, is water runs downhill.
Yeah, I'm pretty familiar with that as well. Do you believe that any water taken passively would need to be licensed under the Healthy Floodplains process?
I think that should be a question to the department this afternoon, but I think it'd be unfair to actually have to license the potential capacity of a channel. Put it to the department this afternoon.
All right, just to confirm, is it you say it's unfair to license passive take?
I think it'd be unfair to actually license the airspace in the top of a channel that under normal operation never sees water, but in a flood it fills it up and you cannot use it. Take the situation where you do have an embargo and the channel is full on the outside of the levee bank and it's impossible to get that water back into the river. You're not allowed to bring it inside the farm. So what do you do? What can you possibly do with that water in that situation? It is passive take. You've got no control over it. It is there because of gravity. It is sitting there. You can't let it in because it's illegal. You can't let it back into the river because it's uphill. So what do you actually consider we should do with that situation? That would be the question to put to the department this afternoon.
I think most people are concerned that properties have been designed to maximise that sort of take, and that's where the questions are going. But I appreciate your feedback.
So, Justin, thank you, Justin. That's it. Okay, everyone, that's the end of our time with the New South Wales Irrigators Council. Can I just thank Jim, Claire and Christine for their time? Thank you very much. I don't think you took any questions on notice, so I don't have to worry about the 14-day spiel. But there may be some questions from members after today's hearing when we get the transcript. And so the Secretariat will be in touch with you about those. So thank you very much for your time. The way this works is you're going to have to leave the meeting so that we, otherwise we shut everyone else down. So if I could just get you to...
Thanks, Chair.
Thanks. No, thank you very much. Thank you.